Welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Ladies and gentlemen, again, welcome to Stephen's Squibs monthly family law CLE. This is the first of a series of CLEs that will be produced monthly that will deal with family law cases, disciplinary issues, and other family law items. Available individually, or you can get a subscription for the entire year at a significant cost savings. I would like to introduce my co-host and partner, Caryn Stevens, no relation. Caryn, are you with us?
I am. Hi, everybody. I'm Caryn Stevens, and I'm happy to be hopping on and co-hosting this with Eddie Stevens, the other Stevens. So, Eddie, you've been doing this a while, and I see that this is sponsored by Stephen's Squibs. So tell us, what's a squib?
I have a particular way of learning, and when I took the board cert exam 15 years ago, I wrote down every element, and I learned by writing these things down, it retains in my memory forever. So ever since that, it's now been since 2004, I have read and summarized every family law case that has come out in Florida. And I can show you an example of how they start off. This is just, I hand write them, and the act of writing these case law, the act of writing them now makes it stick in my head. But then we also type them, we edit them. Caryn, now you've helped me tremendously over the past couple of years fixing all my typos. And eventually it gets turned into a CLE. Our T and I have done a CLE for the past, this is our 11th time doing a 2-hour CLE. And eventually it gets turned into a book where the proceeds typically go to a charity that we choose.
So you and RT have been co-hosting the CLE for a long time. In fact, I remember listening to it when I was a Beebe lawyer back in the day as well. And tell us a little bit about how the CLE has evolved over the years with you guys to where we are now in the first part of 2020.
Well, we initially did it for a different CLE provider, and we were very limited to just audio and basically like a PowerPoint. So even though that CLE provider had the ability to do so much more, it was very technically limiting. And also the funds and the revenues that we created would go to pay for things like lobbying. Now we've created a relationship with the Center for Child Counseling, and it's very important to note that all of the speakers, we don't get a penny of compensation. We're just doing this as a service to the profession and to help us ourselves learn the law, because doing this process, it creates a certain mastery. But all the revenues are going to go to the Center for Child Counseling, and they provide services to underprivileged folks in Palm Beach County that desperately need mental health services. And they're also creating a trauma-informed community. And if we're going to create some revenue, I would much rather it go to something like that. And today, in addition to Caryn Stevens, we have our old friend who has done this with me for many years joining us to discuss these cases. Ladies and gentlemen, please welcome Ralph R.T. Wreck-It White. Ralph, are you there?
Yes, thank you, Eddie, for the introduction. I appreciate it. So the first case that we're doing under this new format, it's the only alimony case we have for today. It is the Williams versus Jones case out of the first DCA. This is an interesting case, Eddie, in that this was a 16-year and 11-month marriage. And the final judgment that was entered in this case it granted the wife permanent alimony. And the husband claimed that the trial court abused its discretion in awarding permanent rather than durational alimony because the wife's did not hit that 17-year marriage because they were married for 16 years and 11 months, 1 month shy of the statutory presumption for a long-term marriage. The trial court treated it as a long-term marriage, and the appellate court affirmed the decision, saying a 1 month is a de minimis period given the length of the marriage, and the trial court was permitted to overcome the presumption as to the length of the marriage necessary to qualify as a long-term marriage. There is a rebuttable presumption that a long-term marriage warrants a permanent alimony award. And in this case, it said that even if the party's marriage falls into a gray area marriage between a long and a short-term marriage, you have to still consider the other factors under 6108. And here in this case, the wife was 53 years old at the time of the dissolution, and the appellate court said that a party's age is not a valid basis to deny permanent alimony absent evidence that the receiving spouse's relative youth would allow the former spouse to earn income sufficient to support a lifestyle consistent with that enjoyed during the marriage. In this particular case, the wife had some health problems that precluded her from being employed, and that weighed heavily in the trial court's decision to award her permanent alimony. So we don't have this really bright line rule. It gives the court, obviously it has the discretion. It said that 1 month is de minimis. We'll see what happens. Maybe 2 months is de minimis, 3 months, and we're just going to leave it up to the discretion of the trial court and the factors under 6108.
I think this creates a slippery slope that would be best avoided, but the first put the opinion out there, and I think you are going to see this applied to not just permanent alimony, but any alimony where the duration of the marriage comes into play, because it's no longer a bright line.
I would agree with you.
So Ralph, this is weird because this is the first time we're doing this where we're actually seeing each other on video. Usually it's just our voice. So in my instance, I apologize to everybody because, you know. But Ralph, you look good today, and I appreciate you.
Thank you. I cleaned up just for you, Eddie.
You look well shaved. So jumping to case number 2, and if you look at the materials, all cases are numbered for easy reference. And it's the Romaine case dealing with agreements. And this talks about contract law. And when you're dealing with MSAs, contract law applies. And in this case, husband sent over a proposed agreement to the wife. He had signed it. He had initialed each page. And the wife, after consulting with her attorney, made 5 changes and sent it back. And she made changes to essential terms of the agreement. The court found that that was an enforceable agreement, and it got overturned by the appellate courts because applying contract law, the wife's response was deemed a rejection of the husband's offer and constituted a brand new counteroffer, which needed to be accepted by the husband. And because it wasn't, we do not have an agreement that was enforceable. That is going to take us to our next fun case to talk about. We're switching down to appeals, and we're talking about case number 5, the Thompson-Melange case. And this is a case where the former wife appealed a contempt order that contained a punishment schedule for the minor child. She requested, first of all, there was a big question on whether or not this was an order that was an interim order that was appealable, and there's a discussion in the case about whether this order that did not give someone the immediate possession of a child, whether that qualified as one of our family law interim orders that we can appeal, and they concluded it didn't. But under writ of certiorari and irreparable damage, it did. And the court put in a really strange provision to enforce time sharing. He made the mother punish the child, and the clause reads as follows. If the child does not go to visitation, the mother had to remove all access to all electronics for 1 week, to include cell phone, smartphones, computers, any kind of desktop, portable, iPad, etc., television, video games, and any other device of similar nature. Upon a second refusal, the penalty got more intense. The former wife shall ensure the child has no contact outside of school, no extracurricular activities with the children's friends for 1 week, and shall not participate in activities with friends that week, except for her school activities. If there was a third offense, the court said, all extracurricular activities of any kind in which the child is participating shall be immediately terminated, not to be recommenced without an order from this court. So under the cert rule, the appellate court did find that there was a departure from the essential requirements of the law, and it did result in a material injury that cannot be corrected on post-judgment appeal, because it was basically an interference with a party's constitutional right to raise their child. So that penalty clause was reversed on certiorari, which is kind of rare in family cases.
You got to give that judge credit. At least he tried. I mean, wouldn't we all love somebody to tell us how to deal with our kids a little better? I mean, it's kind of amusing.
I think all you need to do is just take away the Wi-Fi password and you bring them to their knees. At least that's how I kind of governed my house when I had kids. But yeah, the trial court was trying to achieve something, but apparently doesn't have the authority to dole out that type of discipline to a child. Archie, I think you're up next.
I'm next. That's case number 8. That's the Musinski case out of the 5th District Court of Appeal. In this case, the former husband appealed a trial court order that held him in contempt and threatened future sanctions, including incarceration. In this case, the former husband failed to adhere to the terms of the party's final judgment, and the husband appealed it, and the 5th DCA said that there was enough substantial, competent evidence to support the finding of contempt. But what was interesting is that it warned the former husband that these are going to be the possible things I may do to you in the future if you don't comply with the court's order. And since it was a future potential sanction, including incarceration against the former husband, it was a warning. The appellate court said it's really not an appealable order and dismissed the appeal and remanded for further proceedings, because it was just a threat. It was a threat by the court saying, if you don't follow my orders, this is what I'm going to do. It didn't actually incarcerate him.
Kind of like a purge provision.
Well, I think it was a potential sanction. It wasn't even a sanction. It wasn't, if you don't comply, this will happen. It was, if you don't comply and we have to come back here, this is possibly what I'm going to do to you.
I think that's appropriate, and litigants should be faced with their possible consequences.
Sure, they know what they're, next time they go into court, they know what they're possibly getting themselves into.
Sure. Let's talk about the case number 9, Eaton, which is one of these motion for rehearings, and whether or not you have to file a motion for rehearing to preserve your appellate rights seems to be kind of in flux depending on what district you are in. And in this case, the matter dealt with an oral pronouncement contradicted the ultimate written order in the matter. And the decision appears to be at odds with the 4th DCA, the 2018 case Fox, which eliminated the need to seek rehearing if a court does not address mandatory findings of fact. So they went under Fox and said they didn't need to preserve that issue. But the 4th District reasoned that there was no need for a motion for rehearing where the trial court should have already been aware of the statutory requirements dealing with those other finding of fact case. But in this case is distinguishable from Fox because there was no assertion that the trial court failed to follow statutory mandates of making factual findings. Instead, the court made a mistake. And there are many legal requirements of which a court is presumed to be aware, yet the appellate courts have held that a trial court's errors in failing to comply with those requirements must still be preserved. So in this case, the appellant basically waived their rights because they did not take a rehearing on this particular issue. And again, we're not talking about findings of fact, we're talking about something the judge could have done to correct its opinion. And those types of mistakes still need to be preserved. I think we're going to jump down to our attorney's fees, case 14.
Case number 14, that is the office versus office case out of the 4th District Court of Appeal. In this case, there was a motion to enforce a party's final judgment of dissolution and a premarital settlement agreement. In this case, there was an award of attorney's fees to the former wife. In the trial court awarded fees to the former wife, simply stating that she was entitled to fees and cited to Rosen, the famous Rosen case, and the Bitterman case to support the assertion that she should be awarded fees. However, it's not apparent, according to the 4th DCA, through the record that the wife had a need for fees. And the court went on to state that said, although the trial court citation to Bitterman indicates that they may have awarded the former wife fees under the inequitable conduct doctrine, the order does not list the specific factual findings necessary to conclude that the former husband engaged in inequitable contact. Therefore, they reversed and remanded the order of fees and gave it back to the trial court to make the necessary findings of fact to support the ruling that the former wife has a need for fees, or that the former husband's conduct justified the imposition of fees under the inequitable conduct doctrine under the Bitterman case. You know, Eddie, I've never used the Bitterman case. Obviously, everyone throws Rosen in there. Have you had a case of arguing Bitterman, some inequitable conduct doctrine?
In the 4th, I like Mettler because it's such a clear case, and it's got this great quote in there that parties' financial situation would not insulate them from the consequences of their inequitable conduct. So I prefer Mettler, but I also practice in the 4th DCA. And I just think people, misapply Rosen all the time. And, if you plead Rosen fees, need and ability are still a factor. It's the super factor, in fact. But there are different ways to plead for fees. Like if you're doing a motion for contempt, the court has the absolute right to sanction the other party regardless of their ability. But if you go in on a motion for contempt and say, I want fees pursuant to Rosen or 6116, you're forcing an analysis of needs and an ability. If you go in there and just say, I want to sanction you, or if it rises to a much inequitable conduct is much, it's a greater burden than just violating a court order. And I think those are reserved for, those special types of litigation cases that we sometimes come across. But excellent analysis, RT. You want to jump down to 16?
The next case, 16, that's Schur versus Salervo and Hall, PA. This is a case, it's an interesting case. It's very factual specific, so you should go back and pull the opinion and read it. It's pretty lengthy, but the general context was the court denied a motion for attorney's fees under 57105, and the appellate court obviously reviews this for abuse of discretion, but the trial court's determination of how it got there based on a legal conclusion, such as the interpretation of the statute, is a de novo review. So here, if you go through the case, the requirements for 57105 were clearly met by the party seeking the 57105 fees, and the appellate court stated that when the requirements of section 57105 are met and no exception applies, the statute dictates that the trial court shall, and it underlined shall, emphasis added, award a reasonable attorney's fees. And then it went on to state, however, section 57105 must be applied with restraint to ensure that it serves its intended purpose of discouraging baseless claims without casting a chilling effect on the use of the courts. So as you go through the opinion, and I don't want to get into the nature of the claim, but if you read it, it clearly was that the Salervo's claim was not supported by the law and the material facts to establish a claim, and therefore it wasn't supported by the application of the then existing law to the marital facts. The material facts. And the fourth DCA went ahead and reversed the order denying the 57105 motion and remanded it for further proceedings. So it's an interesting case. It's an 8-page opinion, very factual, intensive, but it sounds like the fourth DCA got this one. I think they got this one correct. If you review the underlying facts, that there was just a baseless claim.
57105 is a tricky statute and has all kinds of procedural requirements. Proceed with caution. Next case we're going to talk about, still under attorney's fees, case number 18, Christensen v. Christensen, and that dealt with a prevailing party clause in an MSA, and the court just simply denied fees without comment, and took it up on appeal. And the appellate court ruled that provisions in ordinary contracts awarding attorney's fees and costs to prevailing parties are generally enforced. Trial courts do not have the discretion to decline to enforce such provisions, even if the challenging party brings a meritorious claim or acts in good faith. Such clauses do not address either spouse's need for support. They merely solidify the party's agreement by providing a disincentive to spouses who may frivolously challenge something. Notably, the marital settlement agreement in this case is governed by contract principles when such an agreement contains a provision requiring fees to be awarded to a prevailing party. Trial courts must enforce these provisions because the former wife was the prevailing party in her enforcement action, as evidenced by the court's order. She wasn't entitled to an award of attorney's fees. Thus, the court erred by denying her request and didn't even mention it. Next case is going to be Zhu v. Chin Liu, and Zhu is the attorney, and Chin Liu are the two parties to the attorney, and this is where the attorney was sanctioned, I think, $1,800. Let me see. The attorney was sanctioned herself, $1,856 for missing a trial. And she had sent an associate there to argue a continuance, and that was denied. And it was based on the fact that she had a court conflict and had another conflict in a federal immigration case. And basically the court imposed the other side's attorney's fees against the attorney for missing the trial. That was reversed because the trial court, again, did not find that the attorney's actions were reached to that level of bad faith, where the court has the inherent authority to award those types of fees. Next case is going to be number 21, which is the McVetti case. The McVetti case, the former husband, it's out of the second. The former husband argues that the trial court erred in ordering the former wife's accounting costs in the amount of $45,000. He had a good argument there because at the beginning of the trial, everybody stipulated that the accountant's reasonable costs were $28,000. So how the court awarded $45,000, we don't even know. A stipulation as to the reasonableness of the fees. So we wouldn't. They actually presented evidence, and the other attorney said, "We don't even need evidence on this. We agree it's $28,000." So when the court awarded $45,000, it was reversed by the second. Next case is number 22, the Johansson case, and attorney's fees were awarded in this case, and the what was it? The fourth DCA reversed it, concluding that the trial court improperly awarded fees after finding the former husband did not have the ability to pay. There was substantial competent evidence to establish the former husband has the present ability to pay. No, the court found there was not substantial evidence to pay her alimony. So if the court makes that finding about alimony, of course it should apply to his ability to seek attorney's fees. Former husband conceded that as a general rule, attorney's fees may be awarded as a sanction in civil contempt proceedings without findings of need and ability. However, in this case, again, the request was brought under Chapter 61, and it was not requested as a sanction. So as a practice tip, I think you have to be very, very careful how you plead these things, and maybe plead them in multiple ways just to cover all your bases. Caryn Stevens, welcome to the show.
Thank you. It's finally my time to hang out with you boys. So next case we're going to look at is case number 25 in your packet. This is the Wolf case. This is out of the second. This is another enforcement and contempt issue, but this one was specifically about time sharing. These folks had been divorced for some time, and they had one little kid between them, and there was some allegations of time sharing being withheld starting on Christmas one year, and the dad had missed a lot of days, and it's a very lengthy opinion. It's about 10 pages long. But what had happened is dad had filed a contempt motion for time sharing, and he went in front of the court and said, I am due a lot of makeup time sharing. And what the court did, the trial court decided, not only am I going to give you makeup time sharing, but I'm actually going to go ahead and just change the parenting plan altogether because I didn't like what mom did or whatever the court was thinking. So they imposed, I think it was some ridiculous number of like 670 makeup days, which is permissible under the statute. But what they did is the trial court decided she was just going to change how the parenting plan looked and gave dad uninterrupted time with this child throughout the entire holidays that year and then on. And once the holidays were over, basically took away mom's weekend time sharing for like months and months and months on end. So mom appealed that judgment, and there's a lengthy discussion about how the modification of a parenting plan is something that the court is permitted to do under 6113 when there's been a time sharing violation. But the issue in this case was mom didn't plead for it, and mom didn't argue that this was in the dad didn't plead for this, and dad didn't argue that this was in the best interest of the child. This was something the court just sort of on its own accord made a decision. So there's a lengthy discussion about 6113, 4C6, and that the court can modify time sharing in a parenting plan in a contempt action, but they have to make really specific findings. The moving party has to allege and prove that, first of all, there's been a substantial change in circumstances because you're making a change, but most importantly, they have to request it. The court has to make a finding that it's in the best interest of the child, and they also have to give sufficient notice to the other parent that they're going to do this. It's sort of a due process issue, to say the least, where they roll in and all of a sudden the court's making ultimate changes to a parenting plan. So that was the Wolf case.
Good job, Caryn.
Thank you.
Is this your first like CLE speaking engagement?
This is. Thank you guys for having me.
Archie, you're up next.
Next is the BIS case out of the 5th DCA. In this case, the parties had a settlement agreement that each party would take one child for purpose of the dependency exemption, In 1 year, the former husband decided that he was going to claim both children, regardless of what the provisions said in the agreement. After the court determined that the former husband violated the modification order by taking both children as tax exemptions in 2017, the trial court ordered as a sanction that the former wife shall claim all eligible offspring as tax dependents for the next 4 years. The former husband took the appeal, and the appellate court said in the instant case, the contempt process utilized was for civil contempt, and punishment for civil contempt is remedial and for the benefit of the complainant. And in here, the court said that the compensation that is intended should actually make the one party whole. But in this case, the sanction imposed went beyond that, and it went beyond compensating the former wife for her actual loss. It essentially punished him by giving up the next 3 years of claiming the child. So on remand, the trial court was to impose a sanction that fairly compensates the former wife for her actual loss.
So what would you do there, Ralph? Bring in an accountant and determine what taxes would have been paid if she had the deduction, and then ask for that amount?
I've seen that done, or I've just seen them say, okay, for the next year, we'll give the spouse both to make up for the loss of 2017. But it's interesting in tax years such as this, where we have these stimulus. It's based on that 2019 return, and I've seen some issues pop up where whoever got to claim the children last year is getting that extra $500. And even though this year may be the tax year that the other party gets to claim the child. So I've seen some of those issues pop up. I haven't had to litigate or file anything about it, but I imagine those are coming.
I have a feeling with the pandemic, we're going to see all types of unintended consequences pop up that we will be dealing with in the very short future. Case number 27. It's a standard enforcement case that a party can't be sanctioned unless they violate a clear and definite provision. In this case, it was ambiguous. It also reinforces the fact that there must be an intent to violate. And if the clause is ambiguous, there's really no intent. And in this case, the appellee conceded error, as they should. And I just want to give props to the two attorneys that did that. One of my favorite law firms down south, Andrew Berman and Jamie Webner for the appellee, conceded error in that case, and the third DCA corrected it. That takes us down to equitable distribution. Reckitt, you're up.
All right, number 29. This is Jackson v. Blazer. Eddie, sometimes the trial court just really get things wrong. In this case, there was an issue as to equitable distribution. The court classified a Chevrolet truck, an Infiniti card held by the former husband, and a Nissan Altima held by the former wife as marital assets, as well as the loan associated with the Nissan Altima as a marital liability. We'll come to find out, looking at the testimony that was before the trial court, the husband acquired the pickup truck prior to the marriage, and the Infiniti he acquired after the petition was filed. The wife acquired her Nissan and took a loan associated with that car after the filing of the petition. So all three vehicles were non-marital and should have been classified as non-marital. So it was remanded back to the trial court to recalculate the equitable distribution in light of the correct classification of the vehicles and the loan. I just find it interesting how do you get this one so wrong?
And
reading it, I'm just like, wow.
And how much did it cost to deal with these three cars that have encumbrances on them? And was it really worth the cost of an appeal? And, these are the types of cases that we really need to settle, because otherwise it's just a disaster for everybody.
I was going to say, they must have spent a lot of money just over a Chevy. What was a Chevy truck?
It's a Chevy truck, an Infiniti, and a Nissan Altima that had a debt on it. But I guess depending on the value assigned, right? It could skew the equitable distribution in favor. You know, if the former husband got awarded the truck that he had premarital and the Infinity car, you know, I don't know how much the values are, but
How much would it cost to order the transcript, though? I mean,
I don't know.
I mean, with proposed ED schedules, that's really wild that the judge would have completely went and made a completely different one and moved cars around. But hey, I mean,
does the case indicate there was proposed judgment submitted, or was this, you know, just done?
I don't believe so.
So practice tip: do really good proposed judgments. Give your judge a template. Give schedules. You know, expecting these judges to get everything right with their current caseload is really optimistic. And whatever we can do to make their jobs easier, I think we have a duty to do so. And crafting good, neutral proposed judgments that a judge would be willing to sign, I think is an art that we need to spend some time developing. And some attorneys haven't done great. Some attorneys don't even submit proposed orders, which it's hard to imagine.
I look back at the case, Eddie. There were 7 issues he raised on appeal, and so there must, you know, this was one of the 7.
Oh,
So that was his winner.
The anticlimactic appeal.
yeah, right. He got his truck.
And the wife was pro se for the appeal as well, so she didn't even get an appellate attorney. So there you go.
She saved some money. I hope it was worth it for good old Mr. Jackson. Our next case, number 30, Sumlin v. Sumlin, and this just talks about distributing stuff, and some of that stuff was a retirement account, and I think we all understand that a retirement dollar does not necessarily equal a dollar in cash. This case teaches us that, and specifically holds that consideration of the consequences of income tax laws on the distribution of marital assets is required, and failure to do so is ordinarily reversible error. And that takes us through our equitable distribution cases for the first 6 months of 2020. And now we are going to go into evidence. In the first case here, number 31, is a doozy because it deals with child hearsay with some very serious allegations. The allegations were the father put the son's penis in his mouth, and that was the allegation that created all of this litigation, and it's a very long opinion, and there's a very lengthy discussion of child hearsay. But basically, we had a very young child make statements about the father to mom, and this is all kind of governed by the evidence rule 9803, specifically sub 23, which is the child hearsay rule. And the child was also taken to a therapist. The therapist was very criticized about her interview techniques. Instead of eliciting a narrative, she asked 15 directed questions. So whether or not there was an indicia of reliability is questionable, but the case basically came down to corroborating evidence and the requirement of corroborating evidence, because we're never going to get someone in trouble just based on a child's statement. In this case, the corroborating evidence was a son would play with his penis, that the interviewing therapist corroborated it, and the appellate court said that's not corroboration. Corroboration is an act. A child playing with his penis is not an unusual thing, and that in itself is not going to corroborate this act. And the fact the therapist thinks that the child is truthful, that is not necessarily corroborating evidence. The common thread in this is that evidence tends to confer, you need corroborating evidence that tends to confirm the unlawful sexual act. The appellate court specifically held that the trial court relied on the testimony of the child who was touching himself while watching television. The testimony indicated the mother observed the behavior, was not alarmed. So the mother wasn't even alarmed by the son touching himself. Because with little kids, sometimes that behavior is normal, unless, and they make a distinguish, unless it's highly sexualized behavior. So there appears to be a distinguish between regular sexualized behavior and highly sexualized behavior. And if the child has highly sexualized behavior, that in itself could constitute corroborating evidence, but here the evidence fell short of establishing that. According to the mother, the child's pantomime was done in response to her direction to show the child what had happened, because he basically acted it out, but did so at mom's direction. And that in itself is another hearsay, even though it's nonverbal. If a person does conduct that is intended to be an assertion, hearsay doesn't just apply to words. And a child's declarant's hearsay statements cannot be other corroborating evidence within the meaning of that section. So based on the findings that the trial court erred in admitting the child hearsay statements, this was a DV injunction case. They vacated the injunction in the Perrott case. And that is going to take us to evidence. It really should have been an injunction case, but child hearsay focuses on that. We're on income now, and the first case we're going to talk about is number 32. That is the Gervell-Richet case. I don't know if I said that right out of the first. And this is a case dealing with imputation, underemployment, where the husband basically abandoned his career voluntarily to pursue his own interest. And the court certainly found that that act was sufficient alone to impute income to the party. 33, Marenko versus Stosinski. Another income case where the trial failed to include losses in the ownership of a rental property. And in my entire career, I've never used losses. If you rent something and the income is less than the mortgage and the payments, that's a negative number. In the past, I've always zeroed that number out because there's so many ways to manipulate that number. But according to the second DCA, you can apply that negative number and reduce someone's income if they have a house that is costing more than is bringing up. And that changes a lot of things for me, because historically I have never put a negative number under rental income. I would just zero it out. But from now on, I will have the Marenko case in my back pocket. RT, what would you do in those circumstances where you would have a negative income on a rental?
I would do the same things as what you're saying right now. In the past, I may have put a negative number on there. I really don't recall.
Depends on who you're representing.
Yeah, obviously. Well, moving forward, certainly you're going to, if there is a loss, you're going to include that in for income purposes.
And I'm pretty sure this is the first case that ever addresses that issue. So it's a board cert folks taking the test. Be mindful of the Marenko case. Hint, hint, nudge, nudge. RT, you want to talk about Haupt?
Yeah, next case is number 34, Haupt out of the first DCA. In this case, it came down to including the husband's bonus income for purposes of calculating child support. The parties both produced financial affidavits to the trial court. The former husband included only his base salary, reporting his gross income. He excluded his bonus income because he said that it varied from year to year. In 2016, the former husband received 8% of his annual salary as a bonus. He received 10% in 2017, and he received 40% in 2018 For 2019, he testified that he expected to receive less than 20%. The husband conceded that, the wife conceded that the former husband's bonus income was not fixed, but she argued that the bonus income that he received over the years should be averaged, and the average bonus amount should be included in the former husband's gross income. The trial court found that he regularly received bonus income, but declined to include this bonus income for child support purposes. The appellate court said that the trial court erred in this omission. Going straight to the statute 6130, it says right in there that gross income shall include, but is not limited to, the following. Number 2, bonuses, commissions, allowances, overtimes, tips, and other similar payments. In this case, the requirement to include the bonus, it was an error for the court to do this. The record shows that the amount varied. Mr. Hopp did receive bonuses in each year from 16 to 18 and anticipated bonus income in 2019. Thus, the trial court was required to include this bonus income. So it gets sent back down to the trial court to compute the bonus income, but I thought it was interesting in that they didn't give direction on what they should do when looking at this bonus income. You have the wife making this argument that it should be some type of average. You have the husband testifying that it's going to be less than 20%. And if you look at the prior year that you actually knew about, it was 40%, which is a huge number for 2018 when you compare it to 16 and 17. So it'd be interesting to see what happened at the time that this thing got remanded.
I think a 3-year average would probably be the best way to go. What do you guys think?
Well, depending on what the number is, if I had the former husband, depending on what the average is, if it was actual 2019 and it was 20%, I'd probably try to argue for what it was actually and not argue for the average. Obviously, depending on who you're representing, you're going to argue for the higher thing. If the average is higher, you're going to argue for the average. If you want to say last year is a better representation, use my actual number from last year.
And I also think it gets problematic where you have years where there's no bonuses, and that gives the obligor even more latitude to argue bonuses shouldn't be included. Like if they didn't get one last year, I think that certainly bolsters their argument.
And then we have it 2020, because who the heck knows what's going to happen with everybody's incomes and bonuses this year thanks to the pandemic. So I think there's going to be some new case law coming out about that.
Are we expecting any modifications coming?
I'm getting ready to try a case. Maybe we settle it, but we're getting ready to try it. And my client's income is down. He's a commission salesperson, so he's still employed. He's getting a base salary, which is a nice base salary, but almost half of his income can be derived from these bonuses. And he's a traveling. I'm going to say he's a traveling salesman, but he travels a lot for sales. And right now he's doing it by Zoom. He's in the medical field, and no one's buying medical devices that are not related to the current pandemic. So the hospitals aren't spending money. He's not selling any medical devices. He's maintaining the relationships with his, the hospitals, but he's not making any sales, and they're not paying him any bonuses. So for alimony purposes, we're just going to argue it's got to be his base. And then as things change, if there needs to be a modification, the former wife can modify them.
Well, Archie, good luck. It sounds like a solid argument. Let's jump down to injunctions. And I'm going to talk about case number 36. And I see patterns in these cases, and they either deal with petty crap, excuse my language, or really serious issues that need to be addressed. And when you have all these petty injunctions coming with neighbors and stuff, it really hurts the ability to protect those that really need an injunction, because judges hear so much stuff that just doesn't meet the burden. It's tougher to get their attention when it's really needed. So let's delve into some of these cases. The first one is Price v. Taylor, which is out of the fourth. The fourth DCA looks at dissolving injunctions a little different than other jurisdictions, because some jurisdictions allow you to challenge it based on the initial procurement. The fourth DCA says, no, you can't do that, except in this one circumstance. if the original injunction was obtained ex parte, where the respondent never appeared, never defended, never participated. In that circumstance, the fourth is now allowing that challenge to the initial procurement. So if you absented yourself from the proceedings, the Price-Taylor case gives you the ability to come back on a dissolution motion and deal with the issues and challenge that initial procurement. I found that very interesting. RT, you have Poland?
Yeah, I'm up next, number 37, Brungart versus Poland. This is out of the second DCA. In this case, the former boyfriend appealed the final judgment of an injunction for protection against dating violence entered against him and in favor of his former girlfriend. And when you read the facts of this case, and I got to get it out there, Eddie, I'm just going to go ahead and just go as quickly as I can to get out what all the allegations were, because it's an interesting case. And when you put all these together, you would think, well, this sounds like a case where there probably should be something put in place, but we'll see what happens. On May 16, 2019, the girlfriend filed a petition for injunction against her boyfriend for protection against dating violence. At the hearing on the petition, the girlfriend testified that she and the boyfriend had been involved in an on and off again relationship for about a year and a half. She described an argument they had on May 2nd, which was 2 weeks before she filed her petition, during which the boyfriend had demanded the passcode to unlock her cell phone. When she refused, he grabbed her by the wrist, pinned her down until she gave him the passcode. A few days later, they both ended the relationship for the last time. The girlfriend told the boyfriend not to contact her again. Nevertheless, over the next few days, the boyfriend continued to send text messages to her, calling her names, criticizing her. He also went to her apartment complex a few times, and after learning that she had moved out, represented himself to the property manager as a furniture delivery person in an attempt to find out more information. During this period, he also contacted the girlfriend's son to inquire about her whereabouts, sent various text messages to her ex-husband, whom she had moved back in with, and some of the texts that the boyfriend included to the ex-husband included videos of the two, the girlfriend and the boyfriend, engaging in sexually explicit conduct. The evidence established that the boyfriend had sent such videos to the girlfriend's ex-husband following a previous breakup in December of 2018. Around the same time, the boyfriend had left his business card on the windshield of the girlfriend's car, which was parked in the driveway of her ex-husband's house. The boyfriend moved out of her apartment and she had moved out of her apartment and back in with her ex-husband after that breakup too. Near the car, the boyfriend had left 2 chairs that she had given back to him during the breakup. She testified the incident made her feel like he was stalking her because the house is in a gated community. She also testified that she was afraid of him, and she admitted that he never threatened to harm her physically. Rather, at some point, he threatened to show the sexually explicit videos to her and her family. At the conclusion of the hearing, the trial court determined that violence had occurred and she had suffered harassment and embarrassment, and the court entered an injunction. So this is another lengthy opinion, and if you're doing this type of work, this injunction work, I recommend that you read it, because the appellate court breaks down each and every aspect of what type of relief you can get in a domestic violence, and it goes through stalking and cyber stalking and being in fear. And at the end, the appellate court concluded that there wasn't enough. The evidence presented did not show that he had done anything to give her reasonable cause to believe that she was in imminent danger of becoming a victim of another act of dating violence. And I thought the harassment, you would think when you hear the word harassment and you talk about, well, you're threatening to show these videos to family, you're threatening to show them to her ex-husband, but it doesn't rise to the legal example of harassment under the case law. So it's a very interesting case to read. I don't really like doing these type of cases. I prefer other people to handle them, but sometimes you get you get pulled into them. But that's a good primer to go through if if you're touching on all aspects of dating violence, cyber stalking, harassment, etc.
And let's drill down a little deeper to some of these elements. Case number 39, Kraft v. Tuller, which is a stalking injunction that was granted, and it what I consider falls into the petty category. The respondent and petitioner were former friends and business partners. That's how it always starts. And they had a falling out several years ago. They have a history of filing injunctions against each other. The respondent began posting tweets on his own personal Twitter feed using the hashtag spoofing schmuck. Do you guys know what spoofing is?
Spoofing?
Spoofing. There's this. I didn't know until I read this case.
Sounds like something young millennials do.
Well, if you read footnote 2 to the case, and this is all new to me. I didn't even know this even existed. Caller ID spoofing is the practice of causing the telephone network to indicate to the receiver of a call that the originator of the call is a station other than the true originating station. So basically creating another phone number to pop up on your caller ID. And it's against the law in Florida, statute 817.487. So in this case, the petitioner was actually arrested for spoofing, and the respondent was tweeting things about spoofing schmuck. But if you have a social media account, that's not a communication directed at the person. It's directed to the entire world. And even though the court granted it here, it was reversed for a couple reasons. One, the comments did not rise to the level of great emotional distress, which is on the burden of the petitioner to prove, not the respondent to disprove. And tweets are not tweets. They are not directed at a specific person. And there's a lot of law that postings on an individual social media page do not constitute actions directed at a specific person as a matter of law. In this case, the Facebook posts do not meet the statutory definition of cyberstalking for two reasons. First, they were not directed, and the testimony showed that they were posted to his own Facebook page. The Fourth District held that the tweets and other social media posts, even though they clearly refer to someone, do not constitute conduct directed at that person, because such tweets and posts are available to see and therefore are directed to a broad audience, as which the petitioner is only one. The court held, and this is where it gets really narrow, where comments are made on an electronic medium to be read by others, they cannot be said to be directed to a particular person. Angry social media postings are now common. Jilted lovers, jilted tenants, attention-seeking bloggers, they all spew anger into fiber optic cables, I love this language, in cyberspace. But analytically and legally, these rants are essentially the electronic successors of the pre-blog solo complainant holding a poster on a public sidewalk in front of an auto dealer proclaiming, "Don't buy here, only lemons from these crooks." So that's a really important element of stalking, is it's got to be directed at a specific person, not at the general public. And the case goes on to talk about substantial emotional distress, and if someone was actually arrested for this, they really shouldn't be that distressed if someone is saying, what they were arrested for. And here there was no record that the respondent's tweets were threatening, menacing, they were not hostile, they weren't even embarrassing. They did mention him by name. They did not mention him by name. They did not tag him, so these might be facts that swing the meter. He was not singled out, and they did not occur in response to an otherwise threatening event that might have changed their character. No objectively reasonable person, not even one with a prior arrest for spoofing, it's kind of funny, would have suffered severe emotional distress as a result of these tweets. And the respondent also claimed he had a legitimate use because he was protesting against spoofing. So that injunction was overturned.
An interesting analysis of all that internet posting. I mean, what a time to be alive, right?
Well, if you're still on these social media outlets, that is, things are crazy, and maybe it's all better we just all take a break. I don't know. Number 40, Mills v. Riley. It was a stalking injunction, and again, there was no evidence of emotional distress, and the court comes on and complains that these injunctions are not meant just to keep parties from who are unable to get along. These injunctions are very serious things, and this is yet another example of it being abused. 41, Kianis Donas versus Mascala is a case where someone sent 38 text messages and had a history of violence, and the text messages were hello, 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 38 of them in a day. But the court DV injunction was either DV or stalking was entered, but it was overturned because dad had a really reasonable reason for making those texts. He had a court-ordered parenting plan that allowed him to have communication with the child, and the mother was preventing that. So the appellate court concluded that the mother's fear of imminent danger was not objectively reasonable, as the father had not recently been violent or threatened violence towards the mothers, and injunctions against domestic violence are not intended to be substitutes for handling disagreements concerning parenting plans or child rearing disputes. Next one, 42. This is a shocking case, and this is a domestic violence injunction filed against his wife by a domestic violence judge, and it was granted. And the only allegation in it was that the wife was going to go talk to the state attorney in the court about the husband's behavior. And the husband, who was a DV judge, was able to obtain a domestic violence injunction just based on that behavior. Of course, it was reversed, and I Googled the judge, who is no longer a judge, Stanley Griffiths III, and prior to this opinion coming out in April of 2019, he resigned as judge, giving no explanation. We might know now why. Ladies and gentlemen, to speak about the Hart-Griffiths case, we have a special guest. We have Abigail Beebe, who is not only attorney of record in the trial court case, she helped out with the appeal. She's a board certified attorney and past chair of the family law section. Abby, are you with us?
I am. Hi.
So congratulations on the Hart-Griffiths appeal. You were part of that case. Can you tell us anything about it?
So I did the trial court hearing on the former husband's petition for injunction against domestic violence. And the former husband was a sitting judge at the time in Gainesville. And they had been divorced for several years. They had 5 children in common. And it was pretty contentious, but the former husband alleged that the former wife was causing him emotional distress due to her contact or allegations that could impact his employment. And after a lengthy hearing before a judge that was appointed to hear the case from a different county, but was sitting in this county courthouse, the injunction was entered. So after my representation of the former wife, which terminated sometime after this hearing. There was a couple other hearings, but ultimately we parted ways, and she did appeal the entry of the injunction. So I didn't participate in the appeal, but I filed here the order was.
And the appellate court basically ruled that, you know, the fact that the husband might be losing sleep over the implications to his employment just wasn't sufficient to support that kind of an injunction.
No, and the evidence that was presented at trial on the record, you know, was clear that nothing she had done really was a bother in any way, and his job was not even jeopardized. This had occurred allegedly on 1 or 2 occasions where the claim actually was that she was trying to get him in trouble for lying about his address for the kids to go to school outside of either one of their counties. So he was living on a farm, and he was alleged to have said that he was renting this place. And I actually had somebody serve that owner of that place, and it was literally like an empty hut, basically.
So you used the return of service to prove it?
I used that. I did have that. I had the affidavit of service. I also had there was another witness that appeared who was the sitting state attorney in Alachua or Levy, I can't remember, who was one of the alleged contacts that my client had made. And he testified that, like, he had given the former wife his cell phone number. They knew each other. She contacted him on 1 or 2 occasions. He returned the call. There was nothing harassing in nature or anything of that kind. But the court found that his emotional distress was legitimate because her allegations could have jeopardized his employment. So, I knew it was wrong at the time, and I was really glad to see that she did end up appealing it. And when it came out, she sent me everything, and I obviously helped the attorney with getting the record and all of that. But it was definitely an interesting outcome, but I'm really glad that it was overturned because it was just wrong. And this wasn't the first time that this man had done this.
Abby, I really appreciate you taking the time today and giving us that special insight that only a trial attorney knows about. So thank you very much.
Thank you.
That takes us to case number 44.
So the case number 44 is Santiago versus Leon. And this is really one that I think everybody should read because it's fun. I mean, it is what it is. So this guy, Mr. Santiago, definitely wins probably the award for the craziest acts of the first half of 2020. And I hope we don't have anybody crazier than him. But Santiago and Leon are 2 men that were in a same-sex relationship. And they purportedly had a child together through a surrogate, and broke up before the child was born. And by the way, these 2 men had a long distance relationships. I don't even know if they were in the same locale as each other, but nonetheless, so they have a child together. And apparently Mr. Santiago starts doing some things that the court called stalking-like and creepy, but not enough to substantiate the legal sufficiency for an injunction. So Mr. Leon, the man who has the child in his care and is the father of this child, files a stalking injunction on behalf of his child and says that Mr. Santiago has done a litany of kind of crazy and stalking-like behaviors. And the court initially granted him a stalking injunction on behalf of his child and to keep Mr. Santiago away. Mr. Santiago appeals, and the court, it was reversed, and they found that there was just not enough legal sufficiency to support the entry of the stalking injunction. But here's what's interesting is some of the things that Mr. Santiago allegedly did toward the minor child. He got a tattoo of the child's name on his body. He posted a bunch of images of the little one on his social media, claiming he was the father and this was his son. He mailed a whole bunch of packages to the house. He emailed the other father all of his love notes and things like that, and expressed his love for this child he had never met. He appeared several times outside the house where the father and the son were living. and he made lots of drive-bys and patronized a bunch of restaurants that Mr. Leon had been with or had been at with his son, allegedly made eye contact with him and some other things. So while the third district found his behaviors to be stalking-like and creepy, that's not enough to have the entry of a stalking injunction against him, but definitely a little crazy.
If someone did that to one of my kids, they might have to get an injunction against me, I'll tell you that, because that's bizarre. That takes us to case 47, Sager.
That is me. Just a note to everyone who's following along, I did notice, Eddie, cases 45, 46, 47, and 48, those are ED cases. So they're just found their way into the injunction area, which is fun. But Sager, we're going to get off topic here, is an equitable distribution case. This is the case of the year, Eddie. Didn't you know that?
Tell me.
Case of the year. The appellate attorney for Mr. Sager was Ralph T. White.
Whoa! I wonder why you picked this case. Well, tell us about your case, Ralph.
I was not the trial attorney. I was only the appellate attorney for this case. So in this case, the court awarded an unequal distribution of the parties' rental property and their marital home, but the trial court failed to identify and value the home, and it failed to indicate exactly how the unequal distribution was going to take place and how to split the proceeds from the sale of the home. So because the court didn't place a value on the home and it didn't apportion the proceeds properly, it was reversed and remanded back to the trial court to make those determinations. And we just had the hearing a couple weeks ago. We haven't got the ruling yet as to what the judge is going to do. So it'll be interesting to see if this, this ultimately comes back in my client's favor. Hopefully it will. So when you're doing an unequal distribution, you have to make certain findings. In this case, the court did not. It failed to identify the value of the home, the percentages, and it needs to identify the basis and explain how it reaches its conclusions when you're awarding an unequal distribution. You just can't award an unequal distribution without explaining how you came about to do it unequally, because you start at the the premise that it's going to be an equitable distribution. But the court can do an unequal distribution as long as it makes specific findings as to why.
Ralph, congratulations on your victory.
Well, thank you. We appealed 4 issues, 2 came back, but we really needed issue number 2 and 3 to come back, but unfortunately they didn't.
You win some, you lose some.
Yes.
That's going to take us to case number 48, Nathy v. Nathy. And to talk about that, we have a special guest, Ward Damon superstar, Gina Sapucki.
We're talking about the Nathy v. Nathy case. And this case is where the trial court awarded the wife half of the equity in a marital home. The husband appealed, and the court incorrectly ruled that the house was marital. What this case teaches us is the husband had this home prior to the marriage that was titled in his name solely. During the marriage, they paid down the mortgage. However, the court incorrectly awarded that it was a marital home because the court should have considered it non-marital property. And in order for it to be non-marital, the husband properly showed that he purchased the home before the marriage, it was titled in his name, and that the house was never transferred during the marriage into the wife's name as well. However, here what the court should have done is, instead of having the entire equity split 50-50, the court should have awarded the wife the marital portion of the appreciated value in the home. that would be subject to equitable distribution.
Thank you, Gina, for that excellent analysis. Our next case is Simpoli v. Clark. It's case number 51 in the materials. And again, one of these petty injunction cases where the respondent annihilated plants on property, would stare at the petitioner from the balcony, and installed a light that illuminated the petitioner's yard. And all of these things were not sufficient to establish severe emotional distress. So we have mainly a string of cases that really come out and prevent these injunctions, because basically they're petty. The next case is 52, the Stanlick case. And this is a case where the petitioner filed a domestic violence injunction, but at the hearing testified to incidents that were not contained in her original petition. Because the vast majority of the evidence related to unpleaded matters, and because the appellate court was not convinced that standing alone, the facts asserted in the petition would have supported a permanent injunction, they cannot conclude that admitting the improper evidence was harmless. And in this case, the injunction was reversed and remanded to be vacated. That was case 52. Next case is number 54, Hobbs. When I think of Hobbs, I think of Calvin. But this is a case, again, dealing with a dissolution of an injunction. And basically, the injunction had been in place 20 years, and there were no real infractions to it. And the trial court denied the dissolving it, and the appellate court came back and granted it. And what I think is really interesting is not really the opinion, but the dissent of the opinion. And in the dissent, basically, it was Judge Bilberry, basically found that reasonable people could differ on this, and the standard's abuse of discretion, and this should not be an automatic rule, but case by case. So there's some information there in the dissent that may or may not be helpful to you depending on your side. The next injunction case, now that we're back on the injunction track, 56, the Toller v. Prey case out of the 2nd DCA. Stalking injunction was reversed and remanded when the respondent was denied the opportunity to participate. Basically, the court did not allow them to cross-examine the petitioner, and we have so many cases that allow the respondent the opportunity to put on a case, and failure to do so deprives them of due process. And I know judges usually schedule maybe 10 or 5 or 15 of these cases in an hour. And if it's one that has serious allegations that the respondent is defending, the court really does have to go out of the way to give the respondent the opportunity to complete their presentation. That takes care of the injunction cases so far this year. Archie, you're up next.
Back on the Sager case, Eddie. See, that's how good of a case it is. You got to use it twice.
You're going to use both of these issues you won, right?
There you go. Yes, sir. Case number 58. Once again, Sager versus Sager. Eddie, I think I owe this win to you based on 11 years of sitting and doing this case law update. How many times have we talked about life insurance?
Oh, so many times.
How many times have we talked about life insurance?
Probably dozens.
Yes, and every year it comes back around.
Got to be affordable. It's got to be available.
There you go. So in this case, we argued that the trial court erred in requiring my client, the former husband, to obtain life insurance, naming the former wife as beneficiary without evidentiary support of or the requisite findings on the former husband's insurability and ability to purchase a policy. The former wife responded that the trial court correctly required the husband to obtain life insurance. And when reviewing a trial court's decision on life insurance policies, it's for an abuse of discretion. As we all know, the courts may require that alimony awards be secured by life insurance on the life of the obligor. However, the trial court must make specific evidentiary findings regarding the availability and cost of insurance, the obligor's ability to pay, and the special circumstances that warrant the requirement for the security of the obligation. Such circumstances have been found that where the wife would be left in dire economic straits upon the death of the husband. Life insurance may also be used when the recipient spouse is disabled, elderly, or has such limited employment skills that the death of the former spouse would cause the survivor to depend upon welfare or the generosity of others. But failure to make the necessary findings in support of the maintenance of life insurance is reversible error. Now, in this case, the judge found that the wife's current financial status and her assets were insufficient for her to sustain herself if the former husband died. She had no investment accounts. She received no retirement accounts. She lives paycheck to paycheck. But here, the judge made she made the requisite findings of the special circumstances, but the findings were devoid as to the availability of life insurance, the cost of the policy, and the former husband's ability to pay for it. Therefore, it was reversed and remanded back to the trial court to determine the availability, cost, and the former husband's ability to pay. What's interesting in this case, Eddie, is my client's 75 years old with pre-existing health conditions. So you can only imagine what the cost of life insurance would be for my client. The evidence at trial was that the life insurance policy had lapsed and he had stopped paying on it. So there was no policy at the time. And we'll see what happens, but I don't think the former wife was able in the remand hearing to come up with the proper evidence for the trial court to award life insurance. So I think we'll be successful on that issue.
Well, I think you have to be careful because not a lot of people appreciate this, but you can secure alimony and child support with other things besides life insurance pursuant to the statute. So if there's an asset that potentially could be tied up, and I think that's a very underutilized provision in Florida law that a lot of people overlook. But good job on the Sager case again, Archie. It's 2 for 2, same case. So let's talk about modification and the extraordinary burden to modify parenting plans. In the Light v. Kirkland case, which is case 59 in the materials, a court ordered a modification after finding the parents could not co-parent effectively and they were otherwise unable to get along. There is an ample authority holding that an acrimonious relationship between parents or lack of effective communication between parents is not a proper basis to find a substantial change in circumstance. In this case, the trial court changed custody from ex-wife to dad, and even caused the kid to change school. And we are reminded that unless it is shown that the conditions have become materially altered since a prior decree, then the extraordinary burden of establishing a sufficient basis for modification has not been met. That's Light v. Kirkland out of the first. Caryn?
So the next case is the Hutchinson case out of the first, and this also was about modifications of time sharing. And in this case, mom and dad had been, or the husband and wife had been divorced for some time, and the ex-wife had moved a couple of times, all local moves. And because of her moves and where she was working, dad sort of assumed and took over some extra time sharing, more than he was entitled to under the terms of the parenting plan. And for many years, he had extra wonderful benefit of more time with his child. And then at some point, as all good amicable relationships go, things sort of fell apart between these two exes, and they went back to following the original time sharing schedule in the parenting plan. And dad came to the trial court pleading for a modification of time sharing. And one of the things he argued was that the informal time sharing that he had been given over the last several years on this informal basis from his ex-wife so he had more time with his child, he argued that that should be the basis for his time-sharing modification, in that he was allowed it, now he should have it. And the trial court granted it, but it was reversed up at the first district, and they said that just having additional informal time-sharing arrangements is not enough as a basis for proving a substantial change for modification. And I guess it goes back to the old, there's language almost in every parenting plan and settlement agreement that says, unless this is done in the same sort of formal writing and all of that, that you can't, just change it. So this was clearly not a basis for dad coming to court asking for a formal change.
Then we have the Judy v. Judy case out of the second, which is an interesting case that dealt with a modification. When the parties got divorced in a 26-year marriage, they did not impute income to the wife at all because she was a stay-at-home mom, and for whatever reason, they just said zeroed her out for income. Then the husband lost jobs, got his job back, lost his job, filed a modification. By the time the modification reached, he was working but not at the same salary, and the court modified his alimony obligation and took into effect the fact that the wife should be imputed income of minimum wage, and dropped her alimony down based on what she should be earning as minimum wage. That was reversed because basically she was not imputed income in the original MSA, so that would not be a change of circumstances that would support a modification in the Judy case. Ralph?
Next up is the Befenis case. This is out of the 5th District Court of Appeal. This is an appeal stemming from a former husband appealing an order denying his petition to modify his alimony. In this particular case, the attorney was a doctor, and he was obligated to pay $12,500 per month to the former wife in alimony. 5 years later, he filed for a downward modification of alimony, noting that he sold his business and he became an employee, and he had an employment contract, and experienced a decrease in his income because he was a salaried employee and he had no longer had an interest in the business. The former husband stated in that petition at the time that he was preparing for retirement, as he was nearing 65 years of age. And over about a year after that petition was filed, the parties entered into a stipulated final judgment that reduced the former husband's alimony down to $7,500 per month. The order did not provide any basis as to how they came about the numbers or the basis for the reduction in the alimony. 16 months after that stipulated order, the former husband again filed another petition seeking a further reduction in alimony. In the petition, he argued that there were two changes in circumstances that supported a reduction. One was that he noted that his 5-year employment contract had ended, and second was he formally retired. The former wife denied the substantial change in circumstances that had occurred since the prior modification. The former husband testified that his income had gone from $40,000 a month down to $350,000 per year at the time of the last modification. And now that he retired, his monthly net income had dropped to $5,135. He testified that although he considered retirement at the time the court entered an order on the stipulated agreement, he did not agree in that order to the contemplation of his retirement income. Rather, he agreed to the terms of the stipulated order based on the reduction of his income following the sale of the business. The wife took the position that she understood that the former husband was going to retire at the time of the modification order and agreed to that order based on this presumption. The trial court denied his request for a downward modification, finding the former husband failed to prove a change in circumstance that was not contemplated at the time of the stipulated modified order. The appellate court reviews this for a standard of review that is mixed, because the legal conclusions that the court made are reviewed de novo. The factual findings are reviewed for competent substantial evidence. The appellate court looked at the nature of the prior litigation and the former husband's retirement and stated that while it would be known that this gentleman may retire at age 65 in the future, that didn't bar him from seeking a future modification. There was nothing in the language of the agreement that would show that the parties contemplated and considered the factors of the former husband's retirement when they agreed to the downward modification of alimony the first time. So therefore, it was remanded back to the trial court to determine, based on the evidence at trial, whether the alimony should be decreased based on the factors of 6108. It's a pretty interesting case. I've seen people get jammed up when they put language about retirement in their final judgments. I'm aware of one case here. It didn't go up on appeal. They were able to settle it, but at the time the parties entered into the final judgment, there was some language about retirement, and the court said that it was contemplated and the guy could not use PIM, and he couldn't essentially use those retirement cases to get out of his alimony obligation. It was interesting, but it didn't go up on appeal. I think they ended up working out. But
And the word contemplate, really means addressed in the agreement. So be careful how you address those things in the agreement.
certainly.
Caryn?
So we're going to switch gears and talk about some parenting cases now. And the first case we're going to talk about is number 64, which is Fry versus Cuomo out of the 4th District. And this case involved a dad, Mr. Fry, who had somewhat of a pretty substantial alcohol abuse issue. There had been testimony at trial from the psychologist who did an evaluation that basically said that the former husband shouldn't drink at all, and his dependence on alcohol and his history of relapse was concerning, and that he should abstain completely. So the trial court put into effect some restrictive parenting parameters for Mr. Fry before he had time sharing with his children, and one of them was that he had to blow into sort of one of those blood alcohol devices at certain times before time sharing, and also he was ordered to sort of do it at any point in time when the former wife demanded it as well. And the court also made Mr. Fry financially responsible for 100% of that blood alcohol testing device, the implementation and the use and service of that. And he appealed, took this up, and what the 4th did is that they affirmed that the trial court had the ultimate discretion to restrict his time sharing and put these sort of protective parameters in place to safeguard the children's interests, and requiring him to do blood alcohol blow tests before he had time sharing was completely within the court's discretion. But what they did reverse on was that the trial court did not have the right to make Mr. Fry, the dad, completely financially responsible for the blood alcohol testing, because it's an incident of child support. And so it should have been either split on a pro rata basis based upon calculations or contemplated in those calculations. So that part of the order was reversed. However, the court does have the right to put these sort of safeguards in place.
But it would be considered a cost of visitation to be pro rata between the parties, right?
Correct, exactly.
All right, that takes us to case number 67, the Sokol case, which deals with parental responsibility. And a parent was awarded ultimate decision-making based on the best interest of the child, and that's the wrong legal standard. The court really has to make a finding that shared parental responsibility is detrimental to the child. So one of the parent's decisions actually have to be demonstrated, and the court has to articulate that those behaviors are detrimental. Now we jump down to case 70. Ralph, you ready?
Yeah, you skipped one of mine, Eddie. So if we don't mind going back on parenting, the Ezra case, number 65.
Oops.
That's all right.
Tell me about
The Ezra. I'm sorry?
Let's talk about Ezra.
All right. Better than Ezra. So the Ezra case is out of the 3rd District Court of Appeal. In this case, the parents were divorced, and they stipulated to a parenting plan that established shared parental responsibility. The mother later moved, the former wife moved to obtain ultimate sole decision-making over medical and educational needs of the children. The court granted that. The father appealed. The standard of review for modifying a parenting plan is for abuse of discretion. Here, the trial court and the record established that the father had both passively and overtly hindered the mother's attempts to foster the happiness, mental health, and academic prowess and overall stability of the children. Further, the father, despite neglecting his financial responsibilities and stipulating to religious day school enrollment, the father repeatedly impeded the registration process and actively sought to undermine efforts to procure a financial affidavit. And without consulting a medical professional, the father, on occasion, reduced his child's prescription drug dosage. So based on those factors, the appellate court agreed with the trial court that the risk of the risk of destabilization associated with the enduring course of behavior is apparent, and the decision to afford the mother sole parental responsibility for the educational and medical needs of the children was well supported by competent and substantial evidence, and therefore there was no error.
I think that's a classic example of detrimental decision-making and totally appropriate. Back to case number 77, Ralph.
Next is the Nishman versus Stein case, Eddie. This is out of the second DCA. This is a paternity action. The father challenged the trial court's order requiring him to pay temporary attorney's fees and costs to the mother. In this case, the father stated that the mother waived all claims for attorney's fees under the parties' stipulated marital settlement agreement. The trial court determined that the language of the agreement was ambiguous, but concluded that there was no waiver of attorney's fees. The appellate court affirmed the order under the tipsy coachman doctrine, which who doesn't love the tipsy coachman doctrine, Eddie? You see it come up every once in a while, so I went ahead and
The Rubin case.
For those who don't know, I'm going to give you a little history on the tipsy coachman doctrine.
Oh, please do.
So the first legal reference to the tipsy coachman appeared in an 1879 opinion of the Georgia Supreme Court. The case was Lee versus Porter, which states the rationale underlying the doctrine. It may be that we would draw very different inferences than those drawn by the trial judge, and these differences might go to uphold the judgment. For many steps in reasoning of the court below might be defective and still its ultimate conclusion be correct. It not infrequently happens that a judgment is affirmed upon the theory of the case which did not occur to the court that rendered it, or which did occur and was expressly repudiated. The human mind is so constituted that in many instances it finds the truth when wholly unable to find the way that leads to it. The opinion then quotes from Oliver Goldsmith's 1774 poem, Retaliation. The pupil of impulse is forcing him along, his conduct still right, with his argument wrong. Still aiming at honor, yet fearing to roam, the coachman was tipsy, the chariot drove home. So there you go. That is the tipsy coachman doctrine. So in here, what the appellate court said ultimately was that the trial court got the ultimate holding right, but it got there the wrong way. So under section 6116, therefore section 742.045, a party cannot waive its right to temporary fees in a paternity action.
That's going to take us now to procedure, and we're going to talk about the Ricketts case, number 72, which deals with ordering personal psychotherapy records when it's not an issue, very similar to the D. Wade case.
Eddie, before we move on, and maybe you might need to fix this too, I'm sorry. I did want to add something else.
Go ahead.
Just in this case, and I think it's important with what we're dealing with right now, is if you look in this opinion, there's a whole separate section that relates to why temporary relief hearings need to be heard in a quick fashion. And I think it's important to note, and people during this time when we're having trouble getting some court time maybe need to bring or use this case to the trial court. In this particular case, I think it took a long time, and I think they did 3 different temporary hearings, and ultimately the court, on its motion for temporary fees for the mother, it says, well, we're just going to defer that to the final hearing. So that was 10 months after her first motion was filed. So it just talks about these, the court needs to handle this in an expeditious manner. You shouldn't delay these rulings. You shouldn't have to have multiple temporary relief hearings to get there. And it describes the importance of these hearings as it relates not only to the financial issues, but also the time sharing issues of the family. So I think this is a case that can be used in these times just to help inform your trial judge, maybe give them a little, incentive to get your temporary relief hearing heard quicker than later.
Thank you. Ricketts v. Ricketts deals with compulsory discovery of mental health records when it's really not an issue. Follows the D. Wade case that came out a few years ago. And, being an issue just doesn't mean making an allegation that someone is mentally unstable. It means basically that, the other parent is unfit to care for the child, and the case has dicta that actually says that. So keep Ricketts in your back pocket when someone is trying to obtain those records. It was also done on cert, which again is kind of rare in family law. Case number 77. Archie?
That is the Bigelow versus Ritsema. That is out of the 5th District Court of Appeal. This is a paternity action. This was the mother appealing an order denying her motion to set aside a final judgment and amend the final judgment. Here, the trial court entered its first final judgment on September 26, 2017. The mother did not timely file a motion for rehearing. Instead, she filed a motion to set aside the final judgment based upon excusable neglect. The court held an evidentiary hearing on the motion to set aside. The court found that the mother had chosen not to participate in the litigation and that her actions did not constitute excusable neglect. 10 months after issuing the final judgment, the trial court rendered an amended final judgment, which made substantive changes to the final judgment, including findings of fact relating to several statutory factors. The trial court's order denying the motion to set aside is supported by substantial competent evidence, and they reaffirmed that ruling denying the motion to set aside. However, it agreed with the mother that the trial court erred in entering an amended final judgment. It looked at Rule 12.530 that states no later than 15 days after the entry of a judgment or within the time of ruling on a timely motion for rehearing or new trial made by a party, the court on its own initiative may order a rehearing or a new trial for any reason for which it may have granted a rehearing or new trial on a motion of a party. This language represents a well-established rule that trial courts have no authority to alter, modify, vacate a final judgment except provided in the Rules of Civil Procedure 1.530 and 1.540. In this particular case, the trial court lacked the jurisdiction to amend the final judgment as the time for rehearing had expired. So that was an interesting one, that the court went back and tried to amend a judgment on its own.
So I guess they're stuck with the same rules as if someone had done a rehearing, and the same time limits apply.
Yes, and there was the motion to set aside was filed more than 15 days after the final judgment in this case. Therefore, it could not have been considered a motion for rehearing filed pursuant to 12.530. Sometimes when people file things and they don't get the titles right, the trial court or even the appellate court say you have to look at the underlying motion and what's in the motion. The title doesn't necessarily control. So
Treat
I think, so the trial court could have treated it as a motion for rehearing, but it was untimely in that it was filed 15 days.
So good. So it was out of luck, and the appellate court was the only recourse. 78, Lunsford v. Engel. This is the first time I've ever had a squib that's crossed out. And it's crossed out because the mandate was recalled. And up until this case, I didn't even know you could recall an appellate mandate. Caryn, can you please tell us how you can recall a mandate?
So when you said you were talking of an angle, you're not actually talking of an angle. Thanks.
Surprise.
Recalling a mandate is a rare thing these appellate courts have the right to do, and it's driven by Florida statute. So under 43.44, a mandate of an appellate opinion can actually be recalled long after it has been entered within a certain time frame. So what the standard is under the statute is that if the circumstances of the case require or impose the appellate court to look at what the opinion was and the mandate that was entered, if there is good cause, they can recall their own mandate within 120 days of it being entered.
Caryn, the reason I ask you this question is because you're the attorney responsible for vacating this mandate, aren't you?
I am with your assistance. We did successfully recall this mandate, and we were permitted to intervene in this case. The case has now been briefed up again, and we're waiting for an opinion. So the Lunsford versus Engel opinion that was originally published and then recalled, now we're waiting for a new, I guess, Engel 2.
So without getting into the facts of the case, I think you should all be on the lookout for the Engel 2 opinion because it's bound to be interesting. That will take us to our next case. I just put Caryn on the spot for that. Caryn, you did great. Number 80, Bradner v. Bradner. That was a summary judgment on a supportive relationship, and for some reason, the facts were not undisputed. And the court went ahead and granted summary judgment, and because there was a dispute, that was inappropriate. Ralph, we're jumping down to 84.
Ramirez versus Ramirez. In this case, the parties had 3 children. The husband filed a petition for dissolution of marriage. In his petition, he sought shared parental responsibility with joint decision-making. At the same time, he also filed an emergency motion to pick up children from Ohio because the mother had left Palm Beach County and took the children back to Ohio. The husband requested that the court place them in his sole, quote-unquote, sole care on a temporary basis. The court granted an emergency hearing on the husband's motion. The wife did not appear at the hearing, but she was represented by an attorney. Following the hearing, the court concluded it had jurisdiction to determine the children's custody. It found that the wife had improperly removed the children from the state. It granted the husband's motion to pick up the children and award him sole physical custody and sole parental responsibility on a temporary basis. The wife filed a motion for reconsideration, but the trial court never ruled on it, and this appeal followed. And the appellate court said the only issue preserved for appeal was whether the trial court violated the wife's due process by awarding the husband sole parental responsibility, even though he never requested that relief in his pleadings. The husband asked for shared parental responsibility in his dissolution proceeding and only asked for sole care of the children in his emergency motion. The court ruled that the husband's request for sole care of the children was sufficient to award sole parental responsibility. The court said that this is a renewal of, they were going to renew this case de novo because it was a pure question of law. And the appellate court concluded that the court erred in awarding the husband sole parental responsibility because his request for quote-unquote sole care of the children was insufficient to place the wife on notice that her parental rights were at stake. Therefore, they reversed the award of sole parental responsibility to the husband and remanded to the court to determine parental responsibility in the best interest of the children based on 6113. but it did also state that the remaining issues on appeal, which were affirmed, could be revisited in the course of regular non-emergency temporary relief hearing. So temporarily took some action to protect the kids, move them back from Ohio to Florida, and then reverse the, I guess, the emergency treatment of sole parental responsibility.
It's going to take us to case 88, Singer v. Singer, which is an unusual set of facts, very unfortunate. The wife at trial was denied alimony because the court imputed gift income to her that she received from her father and her boyfriend, and imputed an additional $20,000 a year in income because of gifts from those two people. After the trial, but before the final judgment entered, both her father and boyfriend died successfully. Both her boyfriend and father died. The wife asked for the court to reopen the evidence based on those facts. The court denied it. The appellate court reversed that decision, and the second DCA said under these unusual circumstances, the motion to reopen should have been granted. And the last case we're going to be talking about falls under same-sex marriages. Not the last one, sorry. Almost took Ralph's thunder away. The next case is McGovern v. Clark, which is a same-sex case where basically dealt with 4 children. 2 of the children were born before the marriage, and 2 of them were born during the marriage. So the 2 children that were born before the same-sex marriage were at issue in this case, and the trial court said that they did not have jurisdiction over those 2 children because they were not born into an intact marriage. And there's a statute out there, legitimacy statute, Florida statute 742.091, and that statute says, where's the statute? If the mother of any child born out of wedlock and the reputed father shall at any time after its birth intermarry, the child shall in all respects be deemed and held to be the child of the husband and wife as though born within wedlock. The appellate court took that statute and recognized that our society is evolving, and terms that were written long ago may not mean the same thing today, and basically treated the non-biological mother to be the reputed father. And it was remanded back to the trial court to determine whether or not the reputed mother would qualify under 742.091. So it's a really interesting same-sex marriage case. And again, if you're taking the board cert test, these are the little questions that turn out to be either true, false, or multiple choice. You may even find a little bit in an essay question, but I would take a close look at that particular case, McGovern v. Clark. Ralph?
I got the last case, Eddie. I got the first case, I got the last case.
You picked them.
Last case is our temporary relief case, Eddie. This is the Cura case out of the 3rd DCA. Pretty straightforward case. There was a temporary relief order that was entered providing for support. The court also awarded a retroactive support award. That retroactive award was challenged in the appellate court, and it was reversed because the trial court never made a finding as to need or actually ability to pay the retroactive support, and therefore it was reversed. Pretty straightforward, simple case.
Well, Archie, thank you for
And now, a discussion of the Florida Bar's disciplinary orders since our last meeting.
Now it's time to talk about ethics. And so far this year, between January and June, the Supreme Court has issued 95 disciplinary orders, which seems to be a pretty high number. We have lost 21 attorneys. 11 have been disbarred. 18 have lost their license due to the permanent revocation. We have 13 attorneys that were suspended until further court action. That's like, oh God, we have to stop what he's doing till we figure out what he or she may be doing. We have 15 public reprimands, and then the rest are suspensions, between 10 days and 3 years. And the way that they are listed in the materials, I organize, these come straight out of the Florida Bar press release, but I like to organize them in a way where they are ranked in ranking of severity, from most severe sanction to all the way down to reprimands. And there are some interesting cases here.
I mean, it's some of the same things we see day in and day out. Eddie, you and I have been doing this once again for a long time, so we review these pretty much on a yearly basis, and the severe stuff is not shocking. You're not surprised that these people were suspended based on the things that they've done, and then it goes down to some of the smaller cases where you're just like, come on, you guys know better. Just follow up with your clients, give them a phone call, do the things you regularly have to do as a business person, and you probably wouldn't be in trouble.
So let's talk about a couple in particular. They're number 2. We have a lot of misrepresentations. Number 2, someone was forging releases, copy-pasted signatures. Number 3, the guy just abandoned his practice and took off.
I think there's a bolo out for him looking for Mr. Toledo. He's just missing. And
then case number 6, I found kind of out there, dealing with a guy was disbarred from getting an enhanced DUI, but that's not the reason he was disbarred.
This wasn't his first foray in the DUI experience. He's got quite a history. He had 4 of them. I think it was in another state, Minnesota. And then he was
4 DUIs,
right.
That he never reported to the Florida Bar.
Oops.
And then it didn't get picked up until he got the enhanced DUI in Florida.
I'm sure he's a lot of fun, though.
Number 7.
You can edit that.
No, that's staying in. Number 7, disbarred for failing to notify your clients that you're suspended.
Yeah.
That seemed pretty severe. A lot of misappropriation cases, always. Those are all, if you misappropriate, you shouldn't have a license. Let's see if we get into some of the funner stuff. I'm up to case number 31, unless you guys have one before that. I don't know what the attorney did, but he committed in-court abuse of the judicial process resulting in great public harm. And so they just suspended him and froze his trust account until the Florida Bar could figure out where they go from there.
I mean, a lot of it is there's a lot of failure to follow up with the bar on these inquiries, and I don't understand it. Maybe they just know that they're caught, but then once you just go for the what do you call it again? Where you just
lawyer assistance?
No, that you give up your license. Where you're just
the revocation.
Yeah.
Administrative revocation, where you can get it usually 5 years later if you're a good boy or girl.
Or person.
And we have a lot of criminal acts. We have some money laundering. I found 46 to be really interesting. Attorney was suspended for 3 years because during a bar investigation, he sent the complaining attorney multiple taunting and harassing emails, and they were retaliatory for the purpose of interfering with a bar investigation. The referee actually suggested a 1-year suspension, and the Supreme Court said, let's do 3.
I guess if you're going to go out on top, right? Take them with you.
In 49, you had an attorney suspended for 2 years for engaging in conduct contrary to honesty and justice and defending proceedings that were frivolous and without merit. And he made some false statements to a tribunal. 50, 2-year suspension for being disrespectful and unprofessional, and being arrested for resisting without violence. So I don't know what's more, what caused the penalty, the arrest or the disrespectful, but a 2-year suspension is pretty significant. 51 I found really interesting, an 18-month suspension because someone was hired to represent someone in a homeowner's claim, and the attorney said he had won and actually created a fraudulent judgment and presented it to the client. And when the client tried to collect, they realized it was forged. 18 months there. We have a 6-month penalty for case number 56, failing to adequately supervise a non-lawyer employee. So, those are still happening and around. 57, an attorney was disciplined, suspended for 180 days for making statements that were disparaging and impugning the integrity of the judiciary with reckless disregard for the truth of those statements. So be careful what you say about courts in the judicial process and other attorneys. 67, 90-day suspension for having a sexual relationship with a client.
I
You
thought
skipped
60.
over. Yeah, go ahead.
Go ahead.
I was gonna say you skipped over, like, I thought, was it 58? I mean, this guy gets hired and he doesn't file anything on behalf of his client for 2.5 years. So note to self, like, file stuff. So yeah, he not the best litigation method, but, and then number 60 I thought was pretty interesting. I wrote next to it, fire guy. So he's not how does one actually, like, get a client who's in trouble for arson and then your own pocket catches on fire in court with your own alleged e-cigarette on fire in court? I mean, that is just lots of fun. I kept hearing, like, the Beavis and Butthead fire in my head when I was reading fire.
But be careful with those vape things, because apparently they explode in your pocket in court. And
I mean,
how do you get that through the security?
How does fire follow one person so much? That's all I just, like, he's just, like, walking, like, Hollywood style with it just behind him is all I'm thinking.
I was looking at 66, and it just, the guy in 66, the guy meant to transfer $7,500 out of his trust account, but he transferred $75,000 from his trust account, which caused a problem in his trust account, and then it led to a bar investigation looking at his trust account where they found more problems. So just doing this small little act that was an accident caused a bigger problem with the bar.
Well, whenever you bounce a check in from your trust account, you're going to get investigated. That's automatic. So, and of course, if you're going to get audited, and any discrepancies will come out. So be careful with those trust checks. 68 was kind of interesting because someone was disciplined for taking on a pro bono case. They didn't even get paid, and they became gravely ill and left the state, and took no adequate steps to protect the client, even though they were gravely ill. And they got tagged with a 90-day suspension. Any other cases that you guys found interesting?
There's a family law case in here. I think it's towards the back.
The guy that slept with his client? Or?
Number 94. Number 94, someone was hired in a pending dissolution matter, sent a joint motion for substitution of counsel to the counsel of record. That person declined to sign the motion without a hearing. The attorney didn't begin proceedings to pursue the substitution of counsel for 3 months. the client terminated the representation, and he failed to timely respond to the bar's written inquiries.
I think
So
he
that
probably
was,
got reprimanded for failing to respond, because you can't ignore the Florida bar.
he was admonished.
All right, well, that takes us through the ethics opinions for the past 6 months. And Ralph, you and I have been doing this 2-hour production now this is our 11th year doing it. And I just want to say it's been awesome. And I hope we're going to be converting this into a monthly series. And I know you're not going to join us every time, but you're always welcome to have a seat with us. And we hope we see you back very soon.
Oh, I'll definitely plan on coming back. Certainly, I can come and work out my material here, Eddie.
Always a safe place. And Caryn, congratulations on your successful debut.
Yes, great job, Caryn.
Thank you. It's nice to bring a little estrogen to the group.
There you go.
And,
Well, the word of the day is mandate. So
well, we know Caryn recalls those mandates. So if
I
you
don't
have
always
any,
recall the law, but I recall the mandates.
I'm here to recall the law. And now we're going to have a very special segment to conclude. There was only 4 people that passed the board certification test this year, and we all think that that's a really low, disproportionate number. So we've put together a panel to discuss and provide some tips to help us have more board certified attorneys. This should not be an impossible task, and we should have a whole lot more experts practicing than what we have right now. So the first 2 attorneys who have offered to provide some tips, they are legends in the Florida bar. I'm talking about Terry Fogel and Scott Rubin, both past chairs of the Family Law Board certification, and Ms. Fogel is also very high up in the BSLE, and 2 of the most respected attorneys in Florida. So without further ado, I introduce Terry Fogel and Scott Rubin with this month's board certification tip.
Stephen Squibbs presents this month's board certification tip.
I'm Terry Fogel.
And I'm Scott Rubin.
And we are with the law firm of Fogel and Rubin. We have been board certified for a number of decades.
We have both been chairs of the Marital and Family Law Certification Committee.
And we have both been chairs of the Board of Legal Specialization and Education, the Oversight Board for Board Certification. We've been asked today to present to you some suggestions that may assist you in preparing for the certification exam. I would like to start with recommending to each of you that you study in depth all rules of procedure, whether they be family, civil, or any other rules that may be applicable to marital and family law. That you equally spend time on all of the statutes that will apply in family law cases, not necessarily limited to Chapter 61, but other areas that are statutorily utilized in marital and family law cases.
As important as the rules and the statutes are, and they're the bedrock of what you need to know, application of the rules and statutes happens in the case law. And there are not all that many family law cases that get reported. You should be able to look at every one of them, at least for the past couple of years, but pay close attention to all of the family law decisions that have been reported where a member of the Marital and Family Law Certification Committee is involved. They're the ones who write the questions. We don't have professional test writers. Similarly, because an exam bank is used, which means that questions from prior years can be repeated, you should be looking for major cases involving prior committee members as well. Those fact patterns will often appear on the exam.
When I prepared for the certification exam, and when I have counseled others to prepare for the certification exam, it has been my recommendation that you consider your preparation as you would consider a consult with a new client. For example, when a new client seeks to ascertain during a consultation the likelihood of success if that client seeks relocation, you must know and must be prepared to discuss in detail during your response to an exam question on relocation the legal requirements and the factual requirements that would suggest to the court that you should prevail on that issue. If you cannot answer the question or give an opinion as to the likelihood of success of a client during a consultation, then you will have great difficulty answering that issue on an exam question. You're very much gearing your answers, as Scott will explain more so, to who it is the exam is asking you to step into the shoes of.
After the fact pattern, each of the essay questions of the exam will, in essence, assign a role to you. In what's known as the call of the question, you will be asked to be the judge, perhaps the judge's law clerk, perhaps the appellate court, perhaps the attorney for one party or another, and then asked to analyze the facts that you're given pursuant to the statutes and rules that apply. And so it's very critical that you read that and answer from that point of view. If, for example, you are asked to be the judge and to not just analyze the different positions, but to reach a conclusion as to what the result should be, and you instead analyze it from one party's point of view and just advocate for that one party, you're not going to do well on the exam.
Finally, a suggestion that we have found helpful to those we have counseled on preparation for the exam is to determine the wheat from the chaff. What I mean by that is, if in fact the question addresses primarily a particular topic such as relocation, do not focus on extraneous facts that are provided in the fact pattern. That is, for want of a better term, a red herring. That is what the committee does in drafting its questions to determine whether or not you in fact are capable and competent to recognize the issue and the facts that pertain to that particular issue. And Scott will give you further examples of that.
Now, Terry told you that one of the examples she gave was a question about relocation of a minor child. That fact pattern could well have contained information concerning the premarital asset of one of the parties. The premarital asset of that party and whether the other party has any claim to that asset might end up being an issue in the party's dissolution of marriage case. But if the call of the question is directing you strictly to relocation, not only do you not need to discuss the premarital asset, but you should not.
And by eliminating those facts that are not relevant to the question being posed, you will save yourself a great deal of time, and you will have the opportunity to complete the answer to the question.
Good luck.
And that brings this month's edition of Stephen Squibb's Monthly Case Law CLE to an end. Now, if you only registered for this particular CLE, we're going to send you an email to allow you to upgrade for $350 to get the full subscription year-long package. We think it's a great deal and worth it, and we hope you do too. And it will also come with a physical copy of my Stephen Squibb book, which will be published in January 2021. We appreciate you registering for this series. We'll see you next month.
Thank you for joining us for this month's edition of Stephen Squibb's Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.